Hello students, welcome to Legacy IAS Academy. In today's video, we are going to discuss about Public Examinations Act that was passed by Parliament in February 2024, and recently the rules regarding the implementation of this act has been released by the government. So in this video, we will try to understand what are the salient features, the key provisions of the bill, and what is the rationale behind the passing, or what basically we can say this passes of this particular act, and why it has again making the news headlines. So first of all, to give you a brief background of this particular topic, the government at the center has notified the rules required to operationalize the Public Examination Prevention of Unfair Means Act passed in 2024. Now, in briefly, if you try to understand, this is example of an anti-cheating law related to examination passed by the Parliament in February, and thus these rules, which has been overall, we can say, explained by the Ministry of Personal Public Grievances and Pensions, provide a detailed framework about how to prevent the use of unfair means in what is referred as public examination. What does the term public examination means? This we are going to discuss in the later part of the video. So including appointing center coordinators for each of the examination centers, venue in charges, as well as the regional officers related to that particular organization and particular examination. Now the question comes that why this rule has, or the why this act was passed and why this rule has been enforced. What is the rationale behind this particular act? So first of all, as we all are aware about, that there is an ongoing controversy regarding alleged paper leak related to the NEET examination that was held few weeks back. In this regard, the Central Bureau of Investigation, that is CBI, a central government agency, is already conducting search, already investigating the matter in the state of Bihar. So, due to this ongoing controversy and the demand of students to cancel the examination, the government is under great pressure, both from the student community all across India, as many millions of students write this examination, as well as under great pressure from the opposition parties in the parliament, which again takes center stage as the government has recently formed in the last month. So, a very large number of cases of question paper leaks, something that also has been something that we have seen happening all over India. And in this regard, if you look at the research that is conducted by a prestigious news organization of India, it has stated that in the last 5 years, if you look at the all India level, total 48 instances of paper leaks, and not in a one or two state, but spread over 16 different states of India, has come into light. Now these are only the cases which has come into light. Maybe many cases are there which never are investigated, about which never there is allegation that is made. So due to this reason, what happens is the future of students basically we can say are compromised, as if you give the examination, you are not sure that whether the selection is happening on the basis of merit or the paper leak or other kind of unfair means has been adopted. So the malpractices that generally is seen in the public examination. Now why in public examination? Obviously because the public examination is one of the major ways how many youth of India get their jobs or get seats in the medical colleges, in the engineering colleges, and variety of other areas. So it leads to delays and cancellations of examination. Also, it adversely impact the prospects of millions of youth, whether students or job seeking youth. So under these circumstances, it was necessary that central government should come and bring a legislation that can deal with the entire spectrum of the conduct of examination and prevention of the unfair means in the examination. So now let us try to understand what is the stated aims and objective of this particular act. So as of now, there has been no specific substantive law to deal with the unfair means adopted or any offences committed during, before or after the conduct of an examination. It is precisely due to this reason, basically the government has stated in its object and vision that to identify and effectively deal with the elements, the criminal elements who are exploiting the vulnerabilities in the examination system by a comprehensive central legislation. Thus, it tries to bring a greater transparency, fairness, and credibility in the entire examination process, especially the public examination process, and thus build a trust between the students, the parents, or overall we can say general public, and the conducting agency, examination conducting agencies, largely headed by the government bodies. So also the other objective of this particular act is to reassure the youth that their sincere and genuine efforts will be fairly rewarded and their future is safe. So basically to promote the meritocracy based system either for admissions in the colleges, universities, or also for any kind of government job. So this is the reason with which the public basically we can say Public Examination Act has been passed. Now let us try to understand that what is the salient features of this particular act and what are the rules that has just been given by the ministry. So the first rule is where it has focused on computer based test. That means the entire examination process will be streamlined, computerized and digitized. That will involve downloading of question paper right there in the examination hall directly from the server. So there is no chances of leakage in between by the intermediaries or agents. And in this regard, NRA, that is a National Recruitment Agency, a central government organization, has been given the responsibility to prepare the norms, standards and guidelines for the computer-based tests that has to be followed in consultation with all the stakeholders depending on which examination is being held. Second rule deals with the center coordinators. So central coordinators, the rules here provides for the appointment of a central coordinator for the public examination. Now, these center coordinators cannot be picked up by randomly. These center coordinators need to be a serving or retired employees either of the central government or of the state government, any public sector undertakings, public sector banks, government universities, autonomous bodies and any other government organizations. So these are the two very important rules. One, promoting and encouraging computer based test, and second, ensuring that the center coordinators, the role of center coordinators, what will be in the examination process. Now the question comes that what are the examination or what are the examinations conducted in India over which these rules can be applicable. So the key term here is over the public examination, and that is actually the name of the act itself. So public examination in this case has been defined under section 2 subsection K of the act, and here it states that any examination that is conducted by the Public Examination Authority listed in the schedule of the act or any such other authority as may be notified by the central government in for that matter will be considered as a public body, and the examination conducted by them can be categorized as public examination over which the act will apply. Now, in the present case, total 4 such organizations are there, 5 such organizations are there over which bill clearly or act basically now we can say clearly applies. These are the prestigious organizations such as the UPSC, Union Public Service Commission, which holds important examinations such as civil service examination. You have CDS examination, you have geologist examination and CMS, many such examinations are there. Second, you have the SSC, that is the Staff Selection Commission, that largely holds examinations such as CGL, CHSL and recruit for the government the officers who are in the group C, D, B and such so and so and so. Then next we have is the IBPS, that is Interbanking Personnel, this we can say Institute for Banking Personnel Selection actually. So IBPS is largely responsible for the appointment and recruitment of the personnel for the banks, that is scheduled banks as well as the commercial banks. And last we have the RRB, that is a Railway Recruitment Board that recruits the personnel for the working in the Indian Railway, which is one of the largest we can say employment generating body in India. So these 5 organizations and any examination conducted by these organizations can be termed as public examination over which the said act applies. So if we talk about the term unfair means, what is the unfair means? That has been something declared or defined by the section 3 of the act. Now as per the section 3 of the act, it mentions a list of 15 actions, if it is carried out, will amount to using unfair means in the public examination for monetary or wrongful gain. Now some of the major we can say list what are the steps or what are the actions that amount to this has been written here, like leakages of question paper or answer key or part of or full. Second is tampering with answer sheets including OMR. Third is directly or indirectly assisting the candidate in a public examination. Fourth is conduct of fake examination or issuance of fake admit cards or any kind of offer letter to cheat or for the monetary gains. So such total 15 actions have been clearly mentioned. If any person, individual or group of individuals are caught involving such actions, then obviously they will be held guilty by as a person who is using the unfair means in examination, and the penalty and the punishment provisions as stated in the act will be applicable over them. So what is the penalty provisions? Now if you look here, first of all, the offenses that is committed under this particular act has to be are considered to be cognizable, non-bailable, as well as non-compoundable. That means you cannot negotiate if you have committed such kind of offenses. Non-bailable, you cannot get a bail. And then second is resorting to unfair means and offenses. If we talk about, if some individual is involved here, then he or she can get imprisonment for a term not less than 3 years, which can be extended even up to 5 years. Not only that, along with that, a person has to pay a penalty or fine of to take 10 lakh rupees. Now, more interestingly, for the service providers, if they have been involved in such kind of cheating, such kind of unfair means, for them the penalty and punishment is much more grave. For example, it provides for fines up to rupees 1 crore and punishment that can be up to 10 years of jail terms for the service providers. So these are the penalty provisions that has been clearly stated in the bill. And also, since this act is applicable over the central government agencies, it is believed by the expert that once this act it has been implemented, when the rule has been given out, now it will also serve as a model draft to states to adopt at their own discretion. That means we know that in India, it is not only the central government agencies or central government organizations or bodies that conduct examination. Even each of the state have their own state bodies, like state public service commissions, that conduct examination. So for state government also to make sure that unfair means are not followed in the examination are conducted with a transparent and fair manner, they can also adopt and take guidance from this act bill and can pass similar bill in their state assembly. So that is all about this particular video. I hope you understood overall about the importance and significance of the Public Examination Act that has been passed and the rules has been given. That is all for this particular video. Thank you very much.